Good afternoon.
Good afternoon.
Good afternoon.
Good afternoon, dear colleagues. Excuse me. Now I have received an email from Professor Adamus. Now I'm trying to answer to his email, and of course, after that we can start the event. I would like to ask your patience until then. Okay, dear colleagues, thank you so much for your patience. First of all, dear colleagues, dear professors, dear viewers, be welcomed here at the open seminar, the fourth one of the research team of legal protection of farmers. I think we could start this event managed by the Institute of Justice in Warsaw. I have previously sent the potential order of the presentations. And in this sense, I think I am the lucky man who can start the present event. Taking into account this, I would like to ask your patience. Of course, I would like to open my presentation. Okay. I hope that you can see the first page of my presentation. I hope so. Thank you so much for your reaction. As you can see, there is a change in the topic of my title that is connected to agriculture irrigation. It's not a coincidence. I can recall I can recall you that during the finalization of the research concept of the present research team, we had different topics. I started my research activity in connection with land market in the chapter of the book. In my chapter of the book, I focused on land market issue, especially I concentrated on international and European aspects of land market. Now, in connection with my scientific paper, I would like to continue my research activity, focusing on environmental challenges they connected to the agricultural. I think there is a great gap between the previous topic and the present topic, and that is the reason. Presentation, I would like to focus on the background of this topic. Background of this topic, and first of all, I would like to focus on the topic. This topic connected to a challenging of the Hungarian agriculture, of course, affecting numerous agriculture producers. This topic is not about the lands, but about the waters, because waters is also element elementary basis of the agricultural activity. And in Hungary, the so-called water governance dealing with this issue. The most important goal of the Hungarian water governance is to improve the storage capability of water of Hungary. What does it mean? How water governance? Maybe it can be a little bit a strange phenomenon for you. This is something about water policy, water institutions, water concepts, and so on and so on. Therefore, it's more than only water policy. Is more than only strategy. It's something focusing on management with water, but in a quite high, quite broad sense. In the maybe the most important mission of the Hungarian water governance is how to store the water on the territory of Hungary. This is the mission. And the basics of these missions, there are two pillars. The one of them connected, of course, to environmental interest. I have to refer to climate change. As to this pillar of the demands, there is a recognition that is water is in the core of sustainable development. It is in core of climate change. There is a recognition that in the future, maybe not so far future, we can feel climate change. What does it mean, climate change? The effect of climate change via water. Therefore, hydrologic cycle, the water issues, they are essential in connection with environmental changes, challenges, and climate change. The second pillar of this recognition of the importance of storage of the water connected to economic interest. There is a recognition that water is the so-called gold of the 21st century, the so-called blue gold. And both of these interests demand a change in the water governance. I think that not only in Hungary, but of course in other states, in other countries as well. These interests, they demand this change, that is to develop, to improve the retention and storage of the water. If I would like to a little bit detail these pillars, this interest, first of all, I would like to start with environmental interest, with the recognition of water that is in the core of the sustainable development. And in connection with this, unfortunately, not fortunately, but unfortunately, nowadays the climate change is a reality, first of all. And the reality is that we could not, now it means humankind, the decision makers, and so on, the other stakeholders, we could not stop, we could not avoid the transformation of the climate. Therefore, the transformation of climate, the climate change itself is the reality. We cannot avoid, therefore, we have to prepare for this transformation. And as a natural demand, we have to improve the so-called resilience. The resilience nowadays is a quite important goal and instrument of environmental protection and the climate issues. This resilience. It is about the adaptation in a given sense. It also demand this kind of storage, the improvement of storage of water. As to economic interest, I would like to refer to the fact that fresh water is a quite valuable and precious natural resources. Of course, we live on the blue planet full with water, but we have to emphasize that only a quite small percentage of this water is fresh water. And besides, in addition to this fact, in a given time, in a given period, we have access to a quite small percentage of fresh water. That is the reason why you can see this quite interesting title on the table, that James Bond of the waters. Fresh water is the James Bond of the waters, because it refers to this percentage of fresh of the water, of the fresh water available for humankind, and this is 0.007. Therefore, the 007 refers to the James Bond. There are some scientific reports, outcomes, according to which, taking into account this portion of fresh water all around the world, the maximum limit with this amount of fresh water is 20 billion people. This amount of people can be supplied by fresh water, but it is a technical limit. And of course, in a given time, in a given period, in a given territory, at this moment, there are great scarcity of water at this moment as well. I would like to refer another interesting issue, that is when humankind use water by consumption. In this case, 70 and or 80% of the consumed water is used by agriculture. Therefore, if we would like to apply freshwater sources in a wise way, in this case, the use of waters by agriculture is an essential issue. From this point of view, I can refer to the situation that according to the water governance of Hungary, the agriculture irrigation is an essential question. Is an essential question, but it is an instrument, and we have to use it in a wise way. In Hungary, experts they determined this wise way as the concept, or via the concept of landscape-oriented water management. Later, I'm going to deal with a concept as well. But now, I would like to focus on legal issues. Previously, I noticed that agricultural irrigation is an important part for the agricultural producers themselves, and not only for the agriculture producers, for the farmers, but also for the society. If we would like to manage a proper agricultural irrigation law, a legal system, in this case, we have to calculate with EU law regulation as well. Now I would like to determine some essential part of this legal framework, some essential one among others, therefore maybe not all of them, but some important and challenging part. One of them connecting to environmental law, of course. There is a huge amount of regulations connected to environmental legislation of the European Union. It is not an easy task to emphasize only one or two elements, but as you can see, I also referred to a quite challenging principle of the environmental legislation, that is the polluter pays principle, which affects irrigation issues as well. Another important element of the EU law's framework is it's connected to specific water management legislation. In the European Union, there is a directive, the so-called Water Framework Directive. It is a kind of umbrella legislation. Numerous parts of this Water Framework Directive and other water directives affects irrigation issues, but I would like to emphasize something: the so-called full cost recovery principle, the financial background of this issue, which a quite challenging one, especially as to Hungary. However, if you would like to develop these aspects of agricultural irrigation, we also have to calculate with other types of EU legislation. For example, rules concerning state aid. Nowadays, there is a new factor of the EU law. It's connected to the human rights. For example, the right to property, which can be essential concerning irrigation issues. As I previously mentioned, I try to focus on some of the elements of EU law. There are other regulation, for example, orientation rules connected to agriculture and rural development support, and so on and so on. Therefore, of course, there are other ones, but I referred only some of them. And now I would like to draw your attention that in connection with Hungary, all country has its own specific water management capacity and water management situation. That is the fact, of course, as to Hungary as well. For example, an interesting element of the Hungarian legislation that we are in the center of the Carpathian Basin. We are in the bottom of this basin. As to the length of different facilities against the water damage, the length of this damage, they are the longest one here in Europe. I think only this one characteristic of the Hungarian water situation, how can I say, prove that for Hungarian producers, the irrigation issues and water issues is essential. That is the reason why, for example, in my previous research, I initiated that we have to deal with this agriculture water law as a relatively separated part of agriculture law and the legal order nowadays. And I initiated in a kind of creation of this scientific field. However, of course, there are other categories, and I think it's quite important to somehow separate these different categories from each other. For example, water management, agriculture, water management. Agriculture water management is regulated in Hungarian Act, the so-called Water Management Act, and water services, they are important, taking into account that Water Framework Directive as well. Therefore, there are different categories connected to the topic of water and agriculture. But what are the differences among them? Some of the issues, some of the topics deals with quantity issues or quality issues or water damages issues or ownership and utilization issues. As to my scientific category, this agriculture water law, I dealt all of this issue. However, as to the Hungarian law, this act of water management, agriculture water management means only the quantity and water damage issue. And as to the agriculture water services determined, for example, by the water management plan of Hungary adopted by the Water Framework Directive, these agriculture water services issues, they focus on quantity questions. As to this agriculture water services, however, there are a kind of definition in the Hungarian strategic documents. According to them, these activities are considered as agriculture water services, and they considered as part of water services determined by the Water Framework Directive. And that is the reason why, for example, irrigation as one of the activities, as one of the water services, agriculture water services, irrigation, it also has to be in compliance with, for example, the full cost recovery principle of the Water Framework Directive. I previously referred that irrigation is important. I also referred that we shall operate agriculture irrigation in a wise manner. But what does it mean, the wise manner? In Hungarian water sciences, because in Hungary, for example, adopted by the Hungarian Academy of Sciences, we have a so-called Hungarian National Water Science Plan. And according to this document, in the core of the water management, there is a kind of landscape-oriented water management, a concept, and we should operate agriculture irrigation applying the concept of landscape-oriented water management. What does it mean, this landscape-oriented management? If somebody is an expert of water sciences, she or he is aware what does it mean integrated water management or adaptive water management. Landscape-oriented water management is something similar. It's an integrated and adaptive water management prepared by or taking into account the Hungarian specialties, especially the characteristics and features of the Hungarian Great Plain. Therefore, when we would like to operate a properly managed agricultural irrigation, we shall take into account, the rethinking of land use, the near natural water flows, and or a landscape-based approach to nature. That is in the essence of this concept, and you can see that I have referred to the Hungarian Academy of Sciences scientific strategy adopted in 2019, which determined this concept. After that, after emphasizing the importance of agricultural irrigation, after emphasizing the legal background as to the EU level and the concept, the most important concept connected to agricultural irrigation, now I would like to concentrate on measures adopted by the Hungarian state to improve agriculture irrigation. It is not an easy question, however, and you can see that since 2011 there are numerous measures adopted by the Hungarian state to develop this system. First of all, it's worth emphasizing that the Hungarian state arranged the most important water ownership issues, and the state, the Hungarian state, tried to regulate this issue, this topic, for long run, adopting or supported by the fundamental law. Fundamental law is the Constitution of Hungary, and Cardinal Act about the national assets. Cardinal Act is a type of act adopted by Parliament. It is an act adopted by the 2/3 majority of the MPs, of the Member of Parliament. Therefore, these essential legal documents provide the legal framework of the ownership issues. Another package of measures connected to the supplying irrigation water to agricultural fields through property owned and used by others, and ensuring access to facilities that provide irrigation water. What does it mean? There is a challenging situation when a given actor, for example, a private actor, for example, a farmer, has an agriculture property, an agricultural land, and between the agricultural land and the given water resources, there is another property. And how can we transfer the water from the water resources to the agricultural land of the given farmer? That is the question. And here we can see some measures in connection with this. This is changes to the previous asset manager and operator structure. For example, some, not all, but some state-owned facilities, for example, irrigation canals, they were managed by private organizations. And after the adoption of a law, these management tasks, they were transferred to the state water management boards. Or some of the irrigation canals, they were owned by municipalities. Municipalities, they are the local government, and they are owned by by local governments, and they were operated by local governments. But the previously mentioned laws, they provided an opportunity for the local governments to offer the operation of their irrigation canals to the State Water Management Board, or as to these municipally owned water courses, the State Water Management Board itself could initiate at the Water Management Authority to transfer or to be recognized as operator of these municipally owned water courses. That was one option how to solve supplying irrigation of water. However, there were other solutions. A different type of solution for water transfer between agricultural fields. It is the irrigation easements. It's a private law institution, and it was also regulated via this development. Another important question, this is the financing issues, financing of investment and operating costs related to agricultural irrigation. And they are subject to EU state aid rules, the polluter pays principle, and the full cost recovery principle. And it's worth noticing that this is, in my opinion, the most challenging point of this issue. Hungarian state adopted numerous measures in connection with this. However, I'm almost absolutely certain that we are not at the end of this development. Another important factor to operate a useful and proper management of agricultural irrigation connected to an institution, to a body, because this complex system demands a state player, a state coordinator. In Hungary, this coordinator is the so-called National Land Center. And last but not least, we somehow, in addition to this National Land Center, we have to operate a planned activity of irrigation. That is the reason why in Hungary the decision makers adopted an irrigation act. They established quite specific communities. These communities they include separate agriculture producers, farmers, and so on and so on. Therefore, these so-called sustainable water management communities, they members are the farmers, and these sustainable water management communities, they recognized by the state. Why? Because communities they should apply agriculture irrigation by specific plans, specific environmental plans. And there is another support from the Hungarian. However, some basic information I provided by these communities, but these plans are Hungarian state itself. And via these plans, Hungarian actors, we try to somehow fulfill the requirements deriving from the EU law, because it's not so easy environmental to fulfill the requirements deriving from the environmental rules of the European Union. The Hungarian regulator tries to do that. Okay, ladies and gentlemen, the next open seminar in August I'm going to detail other parts of this time to provide opportunity for other presenters. Much. There is a kind of Zsófia, can you hear me?
Now, yes,
okay.
But I
Okay.
think something went wrong, but...
Okay, no problem. I can repeat myself. The screen is yours. And as far as I know now, you would like to continue the order of your presentation, focusing on agricultural lands matters.
Yes. Thank you very much. Can you see my presentation?
Yes, definitely. Everything is okay.
Okay, thank you very much. Dear professors, dear colleagues, now in my presentation, I would like to speak about the regulation of succession of agricultural lands and also agricultural holdings in Hungary. And first of all, I would like to speak about that case that I would like to speak these two subjects of the regulation separate. It means that I would like to speak about the regulation of succession of agricultural land, and after that I would like to speak about the regulation of succession of agricultural holdings, because in the previous Open Scientific Seminar, I speak about the Hungarian agricultural holding regulation, or the lack of the classical holding regulation in Hungary. It means that the main subject of our agricultural transaction regulation is the agricultural land. And we have some rules for the agricultural holding, but now it's in a different way. So first I would like to speak about the land, and after that the holdings. And I would like in both categories speak about the two-way how an heir can inherit an agricultural land or holding. These two ways are the disposition of property upon death, or testamentary succession, and the other way is the intestate succession. So first, I would like to speak about the regulation of succession of agricultural lands in Hungary, and first, the disposition of property upon death. And the first thing I have to say that the testamentary succession is under the scope of our so-called main act, the Land Transaction Act, which are already mentioned in the previous Open Scientific Seminars. But we have some special rules in this act for the testamentary succession. But what does it mean that this testamentary succession is under the scope of the Land Transaction Act? It means that the purposes of the act and the Hungarian property policy can prevail in that case. For example, one of the purposes to eliminate the fragmentation of estate structure, and the other purpose is that the person who will acquire the ownership of land has an agricultural expertise. So in that case, in this case, in the testamentary succession, it can prevail. And I said that this kind of succession is under the scope of the Land Transaction Act, But we have some special rules for this kind of succession. It means that the basic rules of the Land Transaction Act for the acquisition of ownership of land are applicable, but some differences. And the main rules, it means, for example, when someone acquiring the land via a sales contract, I can say that this is the basic case. And there are some specialties for the testamentary succession. And from the basic conditions are some basic conditions are applicable for the testamentary succession. It means that the heir has to be a farmer. Another basic condition which is applicable is that the statements are required in the case of the testamentary succession. Which statements are these? In the first Open Scientific Seminar, I already speak about it. It means one of the statements is when the new owner, the acquirer, has to make the statement that he or she will cultivate the land. So these statements are required, and we have to use the land acquisition limit. It means this 300 hectare, this maximum 300 hectare. And the specialties are the following: that the approval of the agricultural administration body is necessary, but there are some differences from the main rules. It means that the examination will be a little bit different in the case of disposition of property upon death. It means that the agricultural administration body shall consider the eligibility of the heir, and as to whether testamentary disposition is predisposed to breach or circumvent restrictions on land acquisitions. The other specialty is that the preemption right is not applicable in this case, and no need to contact to the local land commission. So these last three are the specialties, and the other was the conditions, which are the basic conditions in the Land Transaction Act. And now we can see that in the Land Transaction Act we have a whole section for the disposition of property upon death, but I already mentioned the main rules of this kind of succession. And we have another interested question, because the testamentary succession, the regulation of the testamentary succession of agricultural land is in the Land Transaction Act. And one of the main aim of this act is this kind of principle, which you can see in the slide, that let the land belong to those who can cultivate it. But against this principle, we can mention another principle, a basic civil law principle. This is the freedom of testamentary disposition. And we can say that, of course, since 2013, we have these rules, we have this Land Transaction Act, and the testator knows the rules, and it means that there are some restrictions, some conditions to the heir if he or she want to acquire the land via a will or a testament. So it means that the Hungarian administration body said that I can't give my approval, then the heir cannot acquire the ownership of the land according to the testament. And it's only my suggestion that it can be good, and we can a little bit make closer to these two principles to each other, when the opportunity should be given to the named heir to comply with the conditions laid down in the Land Transaction Act within a specified period. When we speak about a will, a testament, and not about a contract, because the heir can't be sure that he will be in the time of the death of the testator, the named heir according to the will. So I think that we can a little bit make closer these two principles when we give this opportunity. For example, the heir can be a farmer in this period, and of course we have to give the months or years, so the specified period in this act. So I think it can be it's my suggestion, and it can be a little bit better for the civil law regulation, and of course for the Hungarian agricultural transaction regulation. And the other category is the intestate succession. And this is much more different, the regulation for this succession, because the intestate succession is not under the scope of the Land Transaction Act. It means that the general rules of the Civil Code, we have to use the general rules of the Civil Code. But from the 1st January 2023, we have a new rule in the Act on the liquidation of undivided common ownership of land. And in this act, we can find rules in that case when more co-heirs are, so not only one heir, but more co-heirs. And in this case, we have some special rules for the intestate succession. But the main aim of this act is to eliminate the undivided common ownership in the case of intestate succession. And the main aim is to acquire the land in one hand and the transfer of the land in one hand as a unit, but there are no special rules for the agricultural expertise. So this category, this agricultural expertise, does not apply in that regulation. And when we see the regulation of the most countries of Western Europe, we can see that in these countries are sui generis regulation for the intestate succession of agricultural land and agricultural holdings. And in that regulation, both aims apply. So we can say that the Hungarian regulation is not a coherent regulation. But as I mentioned earlier, we have some new rules from the 1st of January 2023. In that special act, it is the act on the liquidation of undivided common ownership of land. And the main aim is to prevent the establishment of undivided common ownership of the land. And the co-heirs have 4 opportunities to avoid this undivided common ownership. In the first step, one of the opportunity is to the co-heirs enter into an allocation agreement. It's between only between the heirs. The other opportunity is to transfer the land to another person who is interested in the succession, or the defaulting heir, or to the creditor of the estate. And of course, in such a way that a common property does not arise. The third opportunity is the co-heirs sell the land as a unit. It means that it is to a third party, so another person who is not in this category, in this who is not co-heir, or who is not interested in this succession. So it's an outsider. So they can sell the land. And the fourth opportunity is that the co-heirs offer the land free of charge for the benefit of the state. And when these previous rules do not lead to results, the co-heirs will inherit the land according to the rules of intestate succession, according to the civil code. So they become it together as co-heirs, but they have 5 years, maximum 5 years, to make this situation clear. What does it mean? That in the end of this period, only one owner will be the owner of the land. And they have, in that case, in this second step, also 4 opportunities. They can sell together to a third party, or one of them will be the owner of the land, or they can offer free of charge for the benefit of the state, or they can terminate the undivided common ownership of the land, and they can use 2 procedures. One of the procedures is the termination of undivided common ownership by division of the land, and the other procedure is the termination of undivided common ownership by acquisition of ownership of land by a single co-owner. And this act is determined these 2 way of the procedures. And if the co-heirs do not fulfill these requirements, the land will be compulsorily sold. And what are the problems with this regulation of succession of agricultural lands? On the one hand, it is a patchwork regulation. It's not a coherent regulation. And the regulation of the 2 ways, the intestate succession and the testamentary succession, are along other principles. And I have another problem with the new regulation. And I think in this act on the liquidation of undivided common ownership of land are a rule which is against the legislator's intention. And I think we have to clarify these rules. What does it mean? That this act this act was established at 2020, and these rules, these sections, what are regulate the intestate succession, it's in this act since 2022, and it's in force since the 1st January 2023. It means that these rules are added later to this act, and I think this is the problem, or this caused the problem, because the main aim of this act is to the liquidation of the undivided common ownership of land. And in this act are some common rules for the acquisition of ownership of land based on this act. But we have to say that this act is the lex specialis, and the Land Transaction Act is the lex generalis. But this act said that in the common rules of this act, that the rules, some of the rules of the Land Transaction Act, we have to not use. And these rules are that the statements are not required, land acquisition limit is not applicable, preemption right is not applicable, and the approval of the agricultural administration body is not necessary. It means that much more easier to acquire the ownership of the land as according to the rules of the Land Transaction Act. But it is not a problem because the co-owners in a main case, and not in the case of the intestate succession, but in the case when we want to liquidate the undivided common ownership, the co-owners are co-owners in the basic case. So it's not a problem that the co-owners have some easier way to acquire the ownership of the land. The problem is in that case when we speak about the intestate succession, and the common rules are applicable for the intestate succession, which is in the section 18A and 18B in that act. And the problem is that in that case, when a third party, a third person, an outsider will acquire the ownership of the land, because the co-heirs will sell the land to this outsider third party, third person. And I'm not sure that the intention of the legislator was that, because it's for this outsider person, it's much more easier to acquire the ownership of the land. And I think it's circumvent the rules of the Land Transaction Act. So maybe the legislator have to think about it, that in that case, when the co-heirs will sell the land acquisition, the agricultural land, maybe in that case the rules of the Land Transaction Act have to be used. It is my suggestion, and I think it is much more. It's a better fit to the legislator's intention, and I think it's caused by the fact that these sections are added later to the act as the previous sections. And the other category is the regulation of succession of agricultural holding. And as I mentioned earlier, Hungary doesn't have a classical agricultural holding regulation. It means that Hungary doesn't have a classical holding succession regulation either. We have only one provision in the Civil Code, which is the disclaimer of inheritance, which is about the agricultural holding. It means that the heir shall be entitled to separately disclaimed inheritance of a farmland and its equipment, accessories, livestock, and tools and implements, if he or she is not engaged in agricultural production by profession. And we have a new special regulation, and we have a new act for the transfer of agricultural holdings inter vivos. It's a very special case. It regulates a very special case. So we doesn't have a special agricultural holdings succession regulation, but we have a new regulation, the transfer of agricultural holdings inter vivos, and the aim of these rules is to help to make easier the generational change. But I will speak about it in the next Open Scientific seminar. And the problems are with the Hungarian regulation of succession of agricultural holdings, that the lack of this regulation does not hold the holding together. The settlement of the succession is only for the main thing of the agricultural holding, which is the land. But the Hungarian land succession regulations, it's not a coherent regulation. My suggestions are that Hungary have to establish the holding regulation, and in this regard, we have to make a regulation of the succession of agricultural holdings, and the regulation of land succession should also fit into this whole holding regulation. And we need a complex system, so the regulation of intestate succession and the regulation of testamentary succession should fit together along the same principles. So my conclusion is that the sui generis regulation of agricultural holdings and agricultural lands succession shall be adopted in Hungary, and the main aims are that this regulation has to be against the fragmentation, and the other very important category, that it should be considered that such person shall be the heir who is competent, has special skills, and has practice in land cultivation. Thus, proper farming would be done on the land. Thank you very much for your kind attention.
Dear Dr. Hornyak, thank you so much for your presentation. And now I would like to call Dr. Srela to deliver his presentation, also connected to these agricultural land issues. Doctor, the screen is yours.
Dear Professor, thank you very much. I would like to ask whether you can hear me and see the presentation.
Yes, everything is perfect.
Thank you very much. Dear Professor, dear colleagues, dear other participants in our open scientific seminar, today's topic I would like to deal with is the succession of agricultural lands and agricultural holdings in Poland. To start with some preliminary remarks, Polish Civil Code in regulation about the succession deals mainly with probably with the agricultural holdings. However, the law from 2003 in the version amended in 2016, this main regulation about the agricultural land and its acquisition in Poland uses mainly the words of agricultural land. However, this law from 2003 referenced to the agricultural lands in the case of agricultural holdings. So when I speak about the agricultural holdings and its succession, it will apply to agricultural land as well. In the other ways, the definition in the Polish Civil Code, as described in the first open scientific seminar, the definition of the agricultural holding depends on agricultural land. So formally, the wording is different, but the effect is, generally speaking, the same. To start with some introduction into a Polish system of succession of agricultural holdings. First, we need to go back to the year 1963. In that year, the law was passed, the law of June 29. The Polish name is in the presentation. It was the first regulation that introduced in the Polish private law special regulations about the inheritance of agricultural holdings. To limit the description to the general rules, successors heirs was entitled by the law, the statutory successors, only if they meet special conditions. The prerequisites, for example, were like this. they need to work in the agricultural production for some kind of period, some kind of years, or they need to have the proper agricultural education. Sometimes rules concerning health who are disabled person who are privileged in some ways in the succession, in the field of succession of agricultural holdings. What's important, this prerequisites, these conditions were different at many times. There were numerous amendments. The amendments were introduced sometimes in the Polish Civil Code, and sometimes by the decree of the Council of Ministers, who regulated the prerequisites for becoming heir of the agricultural holding. You may say that because this is a very complex regulation, this could be the one matter, the one issue, one of the favorites at the bar vocational exam for admission to the bar. The situation changed rapidly, dramatically in 2001 due to the verdict of the Polish Constitutional Tribunal from that year. According to that, to the justification of this verdict, the Polish Constitutional Tribunal stated that this regulation included in the Polish Civil Code, this special regulation about the succession of the agricultural holdings, were not in accordance, were contrary to some provisions of the Polish Constitution. Thus, they were declared null and void at the date of the coming into force of this verdict of the Polish Constitutional Tribunal. So today in Poland, there is a very important date. It is the 14th of February 2001. This is the date of the coming into force, the verdict of the Polish, of the aforementioned verdict of the Polish Constitutional Tribunal. After that time, when the decedent died before that time, we need to apply rules and regulations before that verdict. So all the regulations at the time in force at the time of death of the decedent apply. On the other hand, if a decedent died after or on the 14th of February, the restrictions from the Polish Civil Code do not apply. So we still need to know these regulations, because sometimes the right to the inheritance estates are regulated today, even when someone died many years ago. So formally, they are not in the force today in the Polish Civil Code. However, in the law practice, they are still used in some proceedings concerning inheritance. It is important that that there is a rule that the date of the decedent is decisive in this field. What is also important due to this verdict, because the views, the opinions of the Constitutional Tribunal about the introducing a special regulation about the inheritance of agricultural holdings need to be taken into account when Polish lawmakers try to introduce another special regulation concerning inheritance of agricultural holdings. For example, the rule of the proportion between the need of a special regulation and the right to inherit, and for example, the right to the ownership, as they are guaranteed by the Polish Constitution and guaranteed also by the, for example, European Convention on the Human Rights. So probably these views resulted somehow in the ways that they were regulated in 2016. However, some regulation in this part of the civil code that deals with the special rules on the inheritance of agricultural holdings are still in force, but there are minor regulations on the 3 or 4 provisions. They deal, for example, with the supplementary payment in the case of a legacy. It means that when someone inherit the full ownership of the agricultural holding and he or she is obliged to pay the monetary equivalent of the share to the other heirs, he or she can lower the payment, the amount of the money he or she need to pay to the other heirs. Another regulation still in force is the performance of a legacy cannot result in the division of agricultural holding that is contrary to the proper management. So this aim to guarantee the proper management of the agricultural land is still present in this one of the regulations in the Polish Civil Code. And the third one, the last but not least, it's the rules concerning liability for the inheritance estate debts. The debts connected with the running of the agricultural farm from the date of the division of the inheritance estate are bound, bear only by the heir who inherit the agricultural farm. So the other heirs from that date on, they are not responsible for the debts about the running the agricultural farm. And this is, in fact, the regulations in the Polish Civil Code. However, of course, there are rules in the regulation about the in the law from 2003 in the version of 2016, so-called UKUR in the abbreviation. If we look through the provisions of the UKUR, we couldn't find any regulation that affect the becoming an heir to the agricultural holding. In the Polish legal system, at the date of the death of the decedent, heirs become the owners or co-owners, if there are more than one, of the assets, including agricultural holdings and agricultural land of a decedent. UKUR didn't change that thing. So when the decedent was the owner of the agricultural holding, agricultural land, and he or she died, the heirs become the owners of the agricultural land and agricultural holdings. However, there are other regulations of the UKUR that affect their legal situation. Not the becoming an heir or becoming the owner, but some in another ways limit their rights. And if we look through the provision of the UKUR, you may see that the provisions in paragraphs 1 and 2. This paragraph 1 introduced the main rule, as you may remember, that owner of the agricultural land in Poland can only be individual farmer. So the heirs, they don't need to be individual farmer because of this exemption. On the other hand, this regulation deals with the so-called specific bequest or a specific legacy, and it needs some words of explanation. From a couple of years ago, in Polish Civil Code, there was only one type of bequest, one type of legacy. Now it is called ordinary legacy. The ordinary legacy results only in the obligation of the heir to transfer the ownership to the beneficiary of the legacy of the bequest. So at the time of the death of the decedent, the heir is still the owner of the agricultural land or agricultural holding, but is obliged to transfer it to the beneficiary of the bequest or the legacy. On the other hand, there is a specific bequest that is mentioned in this regulation that at the time of death, it results in the transfer. So there is no need for the heir to conclude another contract, which will result in the transfer of the ownership to the legatee. As you may see, in the wording of this exemption, there are no regulation about the ordinary legacy. It is this difference, this regulation is highly contested by authors in Poland because they insist there are no reason to treat differently these two legatees. In fact, they are treated differently only on the base of the form of a bequest, when the aim of the bequest is still the same, the transfer of the part of the specific asset to the legatee. In fact, I hardly imagine any reason for this differentiation, and this is one of the Lega Ferenda proposals to include the ordinary legacy in this regulation. Another exemption deals with the division of inheritance when the heirs try to abolish the co-ownership. They can do it without being an individual farmer. So this Polish regulation are probably less severe than the Hungarian regulation. We also, when we talk about the inheritance of the agricultural land, we must say that there are special regulations about the foreigners. There is in Polish law, there is a law from 1920. And generally speaking, there is a need to obtain a permission from the state authorities to inherit real estate, not only agricultural, but all the real estates in Poland. Of course, the exception concerns the heirs from the EU member states or the Swiss Confederation. Okay, so this is the regulation about the becoming the heir in the Polish legal system. But this is not the end, of course. The UKUR has introduced some mechanism that will pursuing the aims of the law, especially the aim of guaranteeing that the agricultural land will be properly managed, and the agricultural land wouldn't be divided into many small plots. And this aims are pursued mainly by the regulation called right to acquire. On the previous Open Scientific seminar, we talked about it. This is not preemption right, because in Polish legal system, preemption right concerns only sale contract, because this regulation deals with the legal event, because the becoming owner due to the inheritance is due to the legal event and not the legal action of any. It is done by the fact of the death of the decedent. This is not called preemption right, but so-called right to acquire. And in the this is what is important. This regulation is completely separate from the rules and exceptions mentioned before. So in all the cases, we need to go through the provisions about the right to acquire once again, even when the heirs are exempted from the necessity to be individual farmer. The right to acquire can still apply to them. So, nonetheless, the previous regulation, there is a possibility that the heir finally will lose the ownership of the agricultural holding, even if the light of the previous mentioned regulation, they can be the owner of the agricultural holding. The Article 4, Paragraph 1 of the UQR states that in the case of any legal event, the so-called National Center for Support of the Agriculture, acting on the behalf of the State Treasury, may make a declaration of will that they want to purchase the real estate with the payment of the price equivalent, pecuniary equivalent of the real estate. And when we look about the examples of this legal event that can results in the granting this right to the National Center, there is exactly the word inheritance. So the right to acquire agricultural land applies in the case of the inheritance. On the other hand, there are a list of exemptions from this right, and they are listed in the Article 4, Paragraph 4 of the UQR. And when we go through them, we will find, for example, a person close to the transferor. This regulation rose to the controversy because formally, in the case of the inheritance, due to the theory of Polish private law, there is no transfer, because transfer in fact requires a declaration of will, and we have only a death, which is a legal event and not a declaration of will. So there are disputes whether this exemption from the right to acquire by the National Center applies to the close relatives of the decedent. Another problem is with the next exemption, because when it deals with the statutory inheritance, this regulation results in the very strange situations, because when the decedent prepared a last will, a testament, in which one of the statutory heirs granted the whole estate, inheritance estate. So this heir will become, due to the testament, the only heir. Formally, the wording of this exemption prohibit this exception to apply, because formally he or she become heir not as a statutory heir, but a testamentary heir. And this is another delegate friendly proposal to resolve this discrepancy between the wording of this part of the UKOR and the aims, because the aim of the lawmakers are visible and are obvious, because they wanted to limit the rights of the national center in the case of a person who is in the circle treated by the lawmaker as a close relative and choose heirs to the decedent. The change in the form of the inheritance, when this someone is still the same person, is simply out of the raison d'etre of this regulation. And the same problem as I said previous about the types of the legacies is introduced by the next provision, by the next regulation, letter C. Once again, there is only exception concerning specific bequest, and there is no regulation about the so-called ordinary bequest. And once again, this is probably the mistake in this regulation, and it should be amended to meet both legatees treated the same. Okay, and when we look at the provisions of the Polish Civil Code, there is also one thing that should be taken into account, because the rules of the UKOR, according to the reference included in the Civil Code, results in the necessity of the applying provisions of the UKOR to contracts about the alienation of the sale contract, not only part the agricultural land, the part of the inheritance estate, but also to the sale contract of the whole inheritance estate, if it includes agricultural holding. The same rules of the UKOR apply to the selling or alienating, for example, at the donation contract, due to the donation contract or the exchange contract, to the share in the inheritance estates, of course, if it includes agricultural holding or agricultural land. There is also one minor problem, because, for example, Civil Code in this special title about the inheritance of the agricultural holdings states that this title deals with the agricultural holdings of an acreage that are bigger than 1 hectare, and the UKOR states that its provision apply to the agricultural land that are not less than 1 hectare. So there is a problem what to do with the situation when the agricultural holdings is of an acreage exactly 1 hectare. We must, when we talk about this agricultural inheritance of agricultural holdings in Poland, we need to take into account that this regulation I talked about deals only with the becoming an heir. The regulation about the division of the co-ownership and the liquidation of the ownership of the agricultural holdings that due to the fact of the inheritance are regulated in other provisions, and I would like to talk about them in the next open seminar. To make some summary remarks, the restrictions in the UQR does not affect becoming an owner due to the inheritance. On the other hand, in those situations, the house could lose the ownership of the agricultural holdings because of the rights of the KOVR, which is Polish spelling for the abbreviation of the National Center for the Support of Agriculture. This KOVR can, KAWR can execute its right to acquire agricultural land or holdings and become the owner, but with paying the price of the agricultural land. This right is not this right does not apply in the situation when the successor is, for example, an individual farmer, or he or she inherits of the grants of the statutory succession and not testamentary succession, or the heir is a close relative to the descendant. Thank you very much for your kind attention.
Doctor, thank you so much for your presentation. Now, after two presentation about the topic of land market, especially as to the succession issues, I would like to call our colleague Dr. Czirski to continue this order with an absolutely different topic connected, however, to the agriculture farmers issues. There, Doctor, the screen is yours.
Thank you very much. I would like to ask for a moment. Can you see my presentation?
Yes.
Thank you. So, during this fourth Open Scientific Seminar, I would like to talk about some competition-related laws in agri-food markets. During the first three seminars, I was trying to examine and present the main points of the protection of agricultural producers from a civil law perspective, meaning that I have examined those contract law provisions that aim to provide a protective pillar to the agricultural producers. On the contrary, during this seminar, I will turn my attention to competition regulation in a broad sense, which means that not only antitrust law, but also trade regulation provisions will be touched upon. So I use in this presentation competition law in a broad sense, and when I speak about antitrust law, I only mean under it the prohibition of anti-competitive agreements, the provisions on abuse of dominance, and the merger control. And when I use the term competition law, I also mean under it the trade regulation provisions, which go beyond the scope of antitrust law. On the first slide of mine, you can see some problems from the perspective of producers, which have been already mentioned by me earlier, but these are crucial to understand and get to know when we speak about competition related problems in the agricultural market, and in particular concerning agricultural production. So the whole production production processes vulnerable to weather and climatic conditions, and it results in the lack of predictability for the volume of agricultural produce, and it is more difficult to find a stable equilibrium position between supply and demand, and it comes with volatile prices, and this is the reason because agricultural production functions in cobweb cycles. That means that a large amount of time passes between the decision to produce something and its arrival on the market, and this comes with price fluctuations. And there are some empirical evidence that producers, although they are the ones who sell their products, they are not the ones who determine their price, but they are price takers, which means that the buyer, for example, a processor or a retailer, will determine the price he or she is willing to pay for the agricultural product. This comes from the nature of producers lacking bargaining power, and there are different kinds of buyer power abuses, and in this sense buyer power is also used in a broad sense, because buyer power is not in all cases anti-competitive, but in certain cases it is efficiency enhancing, but competition law and competition law is not concerned with these buyer power abuses. However, it can result in certain market distortions regarding agricultural producers. So overall, producers are the ones who are risk absorbers in the whole food supply chain, because actually they are the weakest market players in the food supply chain. So the central question is how does competition-related regulation protect agricultural producers against the mentioned problems? However, first of all, I would like to speak a few words about policy questions. As you can see, there is a contradiction between agricultural and competition policy, because agricultural policy aims to increase the welfare of producers. However, competition policy, in a broad sense, aims to achieve that consumers can buy the products, any type of products, be it agricultural or any type of industrial products, at the lowest possible price. So it's a contradiction, because we have to balance the interests in the policy-making processes, and basically agricultural producers have a quite good lobbying power, and there are many competition-related alleviations and exemptions for them that can be used for their interest. Basically, the result of this contradiction and this adverse approach of these two types of public policies comes with the winning of agricultural policy, because there are many preferential rules for producers that can be used by them. However, we can see that there are still room for improvement, and we can, from an agricultural policy perspective, we can make these provisions even better if we are willing to use further sector-specific rules. Earlier, I have coined a term which is agri-food competition law, and I call and I mean by it the aggregate of legal instruments that aim to realize agriculture and food policy objectives, created and maintained to regulate the behavior of undertakings in and the competitive process of the agriculture and food market. As you can see on this chart, the whole competitive process can be controlled through two types of means. There are the classic antitrust rules, which have already been mentioned, the prohibition of anti-competitive agreements, abuse of dominance, and merger control. And there are trade regulation rules, which are not covered by conventional antitrust, but go beyond these rules. And the basic difference between these two types of norms, that antitrust rules aim to increase the efficiency, the economic efficiency of the whole market, while trade regulation rules are more concerned with fairness, and that's the reason that these provisions are criticized by many antitrust lawyers. The nature of norms concerning these groups is also different. There are general antitrust rules, and there are exception norms to these general rules, and these exception norms try to alleviate the situation of market players who produce agricultural products. And we can see that trade regulation rules have no general equivalence, but they are specific norms, and they are adopted only for the agricultural market. And as I said, there is no general equivalent which covers the whole economy, but only the agricultural sector. In the area of antitrust rules, the exception norms are related to the conducts of anti-competitive agreements, and which means that there is the general prohibition of anti-competitive agreements in Article 101 of the Treaty of the Functioning of European Union, and in Section 11 of the Hungarian Competition Act. And for the agricultural sector, there are exemptions introduced. And on the contrary, specific norms are more like some kind of, I would say, shadowy concepts that are related to the so-called relative market power, which means that there is no absolute market power in a conventional antitrust sense concerning the respective market. And that's why these conducts which are related to relative market power are many times treated as some corrections of the unfairness of agricultural markets. As you can see, there is an ex post protection system, which means that there is the limited antitrust exemption, which I mentioned comes from the general rule of the prohibition of anti-competitive agreements. I use the word limited because although there is an exemption for agricultural products and in the case of agricultural products, but this is not an unlimited exemption. And also there are some forms of antitrust rules that still apply to the conducts of agricultural producers, and that's why this is limited. So only certain agreements are exempted from the general prohibition. And also there is the prohibition of unfair trading practices, which falls under the scope of the so-called trade regulation rules, and both of these protection systems and sector-specific rules are enforced ex post, which means that the infringement happens, and after it, the agency, the authority will intervene in the market, but by the time typically the competition agency will intervene, the infringement has already happened, so it only corrects the infringing market behavior but cannot prevent it. So it can be seen as a major problem of the protection system, that we do not concentrate on prevention but on, I would say, retaliation of infringing conducts. As you can see, it's not these rules are not uncommon, but we can see many versions of them in almost all countries. But in this chart you can see Germany, Hungary, and the United States, and you can see the relevant provisions of the European Union, and there are certain provisions which are typical for certain jurisdictions, but in general we can say that on both sides of the Atlantic, so both in the European Union and in its member states, as well as in the United States, there are sector-specific provisions that apply to the agricultural producers. The main problem is that despite the fact that there are both some antitrust and trade regulation provisions exclusively applying to agri-food markets, the root cause of competition-related problems in agri-food markets is not addressed at all and or in time, which means that the crucial point would be to prevent the creation of market situations in which the abuse of buyer power cannot come to the fore, and it would be crucial to the attainment of agricultural policy objectives. So what are the objectives of agricultural policy? Is to increase the standard of living of agricultural producers, and because of these buyer power abuses, which are in certain ways covered by antitrust law, and in another way they are not covered by it, but by trade regulation provisions, these situations should be prevented, and this could be achieved by some proposals, and it would require some differentiation in relation to markets from an antitrust law sense. And I think, and I am of the opinion, that we should introduce sectoral merger control rules, and also lower thresholds for abuse of dominance. And these would be the main points to achieve, because, as I have already mentioned, there are no sectoral rules concerning merger control and abuse of dominance, but only concerning the prohibition of anti-competitive agreements. And the first and I think the best solution would be to prevent the creation of those situations when the markets of and the processing markets and the retailing markets become more and more concentrated, and because of this increasing concentration, the processors and retailers become stronger in as regards bargaining power, and they can misuse this situation against the agricultural producers, and this should be prevented by introducing stricter sectoral merger control rules, and as well as we should introduce lower thresholds for dominance, because the main problem is that the abuse of dominant position has a prerequisite, which is the dominance, and the buyers of agricultural products for example, a retail chain is not in a dominant position in antitrust law sense, because these are oligopolistic markets, and the threshold to dominance is not achieved by the buyers. So if we introduced lower thresholds which can be applied ex lege, that would be much easier to go after unfair and disadvantageous market conducts. And I think this would be crucial, because the deterrent effect of competition law is much higher than the rules of trade regulation. So it would be crucial to introduce these kinds of lower thresholds. And my proposal would be a cascading system. And I would say that the processor and retailer is presumed to be dominant if it reaches 35% in market shares in the processing retail market, and if it reaches 35%, the so-called threat point should not be examined. I forget to say that the dominant position is basically declared from 40% of all market shares in the respective market. So if we lowered this threshold, it would be easier to enforce abuse of dominant provisions. So the second step would be that if a processor retailer is presumed to be dominant if it reaches 30% in market shares in the processing retail market or the retail market and reaches the threat point, which is based on empirical evidence is 22%. The threat point means that the buyer actually buys the at least 22% of the products from the same producer. To be more exact, the producer sells its all the 22% of its products to the same processor or retailer, and it means that if the given processor or retailer is not willing to bargain with that producer, the producer will lose 22% of its sales. So it is called a threat point. And after this threat point, the producers can be in a very difficult situation if the given processor or retailer does not want to bargain with the given producer. And the third step would be that a processor or retailer is presumed to be dominant if it reaches 25% in market shares in the processing retail market and reaches twice the threat point, that is to say 44%, in relation to the respective supplier, or I would say the producers. And these would be presumptions for dominance, which means that the first prerequisite of abuse of dominance could be declared ex lege. However, the enforcement agency should still prove that the abuse has happened, which is there is a long list in abuse of dominance rules which constitute abuse. So the authority should, of course, prove that this dominant position has been abused to the detriment of the undertaking suppliers of agri-food products. And based on the same methodology, I think we should introduce sector-specific rules in merger controls. The lowest level of dominance, which can be found in a preamble of the merger regulation, which is 25% of market shares in the respective market, it declares that the impediment of effective competition is not likely when the market share of the undertakings concerned does not exceed 25% either in the common market or in a substantial part of it, which can see the contradiction that the abuse of dominance, and within the abuse of dominance enforcement, the dominance is only declared when approximately 40% of market shares can be found. However, in another legal act, the merger regulation in its preamble declares that it is imaginable that with 25% of market shares, the given undertaking is in a dominant position. So I think we should correct the level of market shares required to prove dominance. And adopting these numerical measures in connection with merger control and introducing the obligatory assessment of economic dependence post-merger would be a significant step to further protecting the agricultural producers, and the buyers of agri-food products would be more obliged to follow the rules, and they could not be able to misuse their bargaining power. Thank you very much for the attention.
Dear Dr. Czyrsky, thank you so much for your contribution. Taking into account that there is a summer holiday, I think that now there are only 4 presenters, and we are going to arrange the presentation of another colleague in another way. Dear colleagues, my question, whether do you have any comments, notes, or something similar, or questions to the other presenters? If not, in this case, I would like to draw your attention that we are going to continue our presentation series in August, as far as I know, but I check my calendar. At the end of August, it means that 31st of August at 4 o'clock p.m. or 16 o'clock. Please do not forget that we have to finalize our book chapters in some days. Therefore, of course, I'm waiting for your written contribution, and of course, I'm also wait for your reports. However, I received 2 of them reports as well. Thank you so much for your contribution. Have a nice evening, and see you soon.
Thank you. Bye.
Thank you very much.
Thank
the same
you.
to you, dear
Bye.
Professor.
Bye.